I'm still Stephen Gold and still the author of The Return of Breaking Law, which would make a superb Christmas present, and I'll tell you later what to do if the pages fall out, which of course they won't.
2 of my pages came out.
You tore them out because I mentioned your name on 2 of them. I suppose you wanted them displayed on the toilet wall.
I'd rather not say.
You know they weren't perforated, don't you?
I have a cunning plan, sir.
If I had a spare £5, I'd wager it on court fees going up next March.
A £5 each way?
No, to win. Not all court fees, just 202 of them. Civil fees in the High Court, the County Court, the Family Court, tribunals, and for good measure, probate and Court of Protection fees as well. And going up by 20% for most of them. No increases for kicking off a money claim or paying a hearing fee in the High Court or County Court. I'll give you, though, an idea of what I reckon some of the new fees will look like. To start a divorce case or a case for nullity, or to end a civil partnership, £652. To issue a Children Act application involving a dispute over residence, contact or something else to do with the welfare of your child, £255. To issue an application in the course of High Court or County Court proceedings, £303 or £119 if it's an application made with the other side's consent. So if a fee is payable by you and it's set to rise, you'll probably save 20% by pulling your finger out before March 2024.
And the help with fee scheme?
I recently covered the radical changes in that scheme in my video number 28.
Bingo!
Actually, your prize could be no fee to pay or a reduced fee because of the changes. You can apply online or by post for this help, and they've just updated the application form, guidance, and a calculator to work out if you financially qualify for help, which all reflect the changes that have been made as from the 27th of November 2023. Take a look at my video and you will find the updated stuff online at, and here it comes,
gov.uk/get-help-with-court-fees.
Your legal rights are the same whatever the time of year it is that you're buying, but as you're more likely to be putting your hands in your pockets in December, I thought I'd mention Christmas and hope it's not too late. If your purchase is defective, you are at your legally strongest in rejecting whatever you've bought within 30 days of getting it. Special rules for perishable items, though. You might like longer, just in case the defects fail to show up within 30 days, while the seller can agree to extend that period. Get the seller to write on the invoice or till receipt that your right to short-term rejection, those are the magic words, short-term rejection, is extended to so many days. Say you will only buy on condition that they're prepared to do that. If your purchase costs more than £100, I recommend buying using a credit card so that you can claim against the credit card company as an alternative to the trader, where the trader has gone out of business or is just being difficult. This may not be legally available where there's an intermediary who has processed the payment. You might not necessarily know this. That will be the case, though, with a PayPal purchase, for example. In order to get this protection, often known as Section 75 protection, it's under the Consumer Credit Act, it isn't necessary for the entire purchase price to go on the card. £5 on the card and £100 in cash, that would be good enough to make the credit card company have to stump up 100% compensation. And that compensation can include consequential losses on top of a refund of the purchase price where the item was substandard. If you bought using not a credit card but a debit card, then the card issuer may be able to organise a refund of the purchase price where the goods aren't up to legal standard under the so-called chargeback scheme. But you won't get consequential losses there, as with a plus £100 credit card purchase. Changing your mind about what you've bought is not a valid reason for getting the price back so long as the goods were up to legal standard. But the seller may run a special returns policy. Well, if they do, you've got to comply with the conditions of the policy. Where, say, there has to be a return within 14 days, you cannot complain to the seller on being told you're too late because you tried to return outside the 14 days. Where you had to produce a receipt, you cannot complain on being told no receipt, no return. However, if these conditions were not brought to your attention before you bought, say on a conspicuous notice behind the cash till or by an assistant verbally, you wouldn't be bound by them. If they were brought to your attention on the till receipt, that's after the purchase has been concluded legally, and you weren't aware of them previously, that would be too late to enable the seller to rely on them. You wouldn't be bound by them. If the goods were not up to legal standard, your inability to produce a receipt should not be fatal. It shouldn't be fatal to securing a refund and any compensation to which you're legally entitled. See, the law does not provide that thou shalt waive a receipt at the face of the seller. It's reasonable, of course, that the seller should be satisfied that you purchased the item from them and not from their rival down the road. But if no receipt, no credit card statement, and you've got no other helpful document to show that you have paid for the item from this particular shop, well, your word should be good enough. Provided you're not an inveterate liar. You're not, are you? It can be good enough for a judge in the county court. It has been good enough for me as a judge in the county court. Where it is the person to whom you gifted the item who is complaining that it's not up to legal standard, then the seller is entitled legally to say, push off, it wasn't you who made the contract to buy with me. Now, there are two ways to overcome this in the case of a gift purchase. One is to get the seller to agree that if you buy, they will write on the invoice or till receipt, for Nellie McFarlane, who can enforce all legal rights against us. But if this wasn't done, well, you can write on the gift card, I hereby assign all rights and remedies under the contract with whoever you bought from for the purchase of this gift to you, Nellie McFarlane. And then Nellie can notify the seller that you've done this. Rights under the Consumer Rights Act of 2015 are given to individual consumers, and not someone buying for a business, a non-consumer. But if the dominant purpose of the purchase was private, the Act may still apply, as it would if, say, you bought a laptop for 75% personal use and 25% business use. Online, you should generally have the right to cancel within 14 days of delivery, just because you change your mind if need be. The Consumer Rights Act applies to sale and other discounted purchases as well as new items. You cannot complain about a defect which was brought to your attention before you purchase, though, and if you examine the item before you purchase, you cannot complain about a defect which that examination should have revealed. The price you paid may be relevant as to whether the item is of a legally satisfactory standard, but even with a 95% discount, it must still work.